faces. Welcome back. The Epstein cover-up has been in operation for years, and I'm about to expose it. This episode is another thread of emails from the newest batch of the Epstein files DATASET 12 that was just released. Now, the FBI is very crafty. They have deliberately released these documents in reverse order to try distract and confuse anyone trying to review them. Now, in order to fully expose these emails, I have to read them from back to front, instead of front to back, which is the normal way in English. So let's now read these emails in the correct order, not the how the FBI wanted us to read them. The email reads as follows. U.S. Department of Justice, United States Attorney, Southern District of New York. The Silo J. Mallow Building, 1 St. Andrews Plaza, New York, New York, 10007. November 11th, 2021. By electronic mail. Christian Everdell, Esquire. Mark Cohen, Esquire. Cohen and Gresser, LLP. Laura Menninger, Esquire. Jeffrey Pagliuca, Esquire. Haddon, Morgan and Foreman, P.C. Bobby Stemheim, Esquire. Law Offices of Bobby C. Stemheim. Re. United States v. Ghislaine Maxwell, 20 Crossing 330, MN. Dear Counsel, today we are producing the materials listed in the below index. These materials are stamped with control numbers SDNY_GM_02771-981 through SDNY_GM_02771-983. Please note that both this letter and the enclosed materials are governed by the July 31, 2020 protective order in this case. This letter is itself designated as confidential because it includes information regarding records designated as confidential under the protective order. The Department of Justice directed this office to cease the dissemination of materials marked with the word confidential in order to avoid potential confusion with markings reserved for classified documents. Accordingly, in order to note the appropriate designation of this production under the operative protective order in this case, the materials being produced today are marked with the following label: subject to protective order, paragraph 7, 8, 9, 10, 15, and 17. This marking directly refers to the specific paragraphs of the protective order that govern today's production. An index of the materials contained in this production is below. Page 2. Bates Start Bates End Summary Description. Confidential Designation. SDNY-GMO 2771981, SDNY-GMO 2771983. Amazon Records. Although the government believes that all of these materials are also located in the Florida FBI file and were previously produced to you from that file in the fall of 2020, out of an abundance of caution, the government is producing these records to you in the form in which they were stored in the files maintained by the U.S. Attorney's Office for the Southern District of Florida. The government recognizes that its discovery obligations are ongoing and will promptly produce any additional discoverable material of which it becomes aware. Please do not hesitate to reach out if you have any difficulty accessing these materials. Very truly yours, United States Attorney by United States Attorneys. Odin, EFTA 000100180 and EFTA 000100181. From Redacted. Sent. Friday, July 9, 2021, 4:52 p.m. Subject. Discovery. I hope you are all well. I wanted to circle back with you about two discovery issues. First, a little while back you said that you would be producing to us additional non-testifying 3,500 material. When can we expect to receive that? Second, you produced the last few productions to Ms. Maxwell on disk. Those disks are now not working. We will drop off a hard drive to you on Monday. Please reload those productions onto the hard drive and send it to Ms. Maxwell in MDC. If the additional non-testifying 3,500 material is ready to be produced, please include that on the drive. Regards, less than image 00I JPG greater than New York I Paris I Washington DC London. Less than image 002.jpg braided. Confidentiality notice. The information contained in this email may be confidential and/or privileged. This email is intended to be reviewed initially by only the individual named above. If the reader of this email is not the intended recipient or a representative of the intended recipient, you are hereby notified that any review, dissemination or copying of this email or the information contained herein is prohibited. If you have received this email in error, Please immediately notify the sender by telephone and permanently delete this email. Thank you. Privacy. A complete copy of our privacy policy can be viewed at Kohangrasser-Privacy-Polix. From Redacted. Sent Monday, July 12, 2021, 9:55 p.m. To Redacted. CC. Redacted. Subject. Discovery. Hope you are well too, thanks. We should have a production of additional non-testifying witness materials prepared to produce to you by the end of next week. Did you drop off a hard drive today? If so, would you please let me know to whom it was addressed? And I are both traveling this week, and our paralegals are currently either out of the office or on trial, so we'll need to get someone else to pick up and load the drive. Thanks. Redacted. Assistant United States Attorney, Southern District of New York, 1 St. Andrews Plaza. From Redacted. Sent Monday, July 12, 2021, 10:57 p.m. To Redacted. CC. Redacted. Subject. RE. Discovery. We dropped off the drive this afternoon. It should be addressed to. Let me know if you have trouble finding it. Thanks. Redacted. On July 13, 2021, at 12:29 p.m. Hi team. Redacted. Redacted wrote, any chance one of you would be able to track down a drive that Maxwell's lawyers dropped off yesterday for please? Or if not, any chance you could point us to someone who would be able to help find the drive? We need to get it loaded, with the most recent productions that went to Maxwell on CDs. Thanks. Redacted. From Redacted. Sent. Redacted. To Redacted. CC. Redacted. Subject. Discovery. I can handle. Currently unpacking some stuff from trial, but we'll look for the drive and try and load it later this afternoon. Could one of you please just let me know what discovery needs to be loaded onto it? Or since which date, since I've been out of the loop for a bit? Sent from my iPhone? From Redacted. Sent Tuesday, July 13th, 2021, 1:16 p.m. To Redacted. CC. Redacted. Subject. RE. Discovery. The most recent productions that have gone to Maxwell at MDC and that we have not already reproduced on a hard drive are the 21st of May, 2021, disc. The 17th production, saved here, includes subpoena returns, native carved images and images. The 10th of June, 2021, disc. Reproduction of the 17th production, above caret, after original disc was sent back to us. The original disc worked on my end, so maybe it is a problem with the larger 8 GB discs we had to use. Nevertheless, the materials to be loaded are the 17th production. Thanks, team. From Redacted. To Redacted. CC. Redacted. Subject. RE. Discovery. Date. Tuesday, the 13th of July, 2021, 21 hours 14 minutes and 32 seconds p.m. Attachments. The 13th of July, 2021, MDC, Maxwell. Password.docx. The 13th of July, 2021, MDC, Maxwell main.docx. Cover letters for this drive are attached. Let me know if they're okay to go out. The drive is being loaded now with the materials inked below. Thank you. And will go out with FedEx either this evening or tomorrow morning, depending on when the drive finishes loading. From Redacted. Sent Tuesday, July 13th, 2021, 3:30 p.m. To Redacted. CC. Redacted. Subject. RE. Discovery. Thanks very much to you both. Odin. EFTA00010143, EFTA00010144, and EFTA 00010145. From Redacted. Sent Wednesday, November 10th, 2021, 11:09 p.m. To USANYS Redacted. Contractor. USANYS Redacted. Contractor. CC. USANYS Redacted. Subject. Amazon Return. Hey ND Redacted. Thanks again for all the help today. When you have a chance, would one of you mind adding this to the next Discovery folder and to a folder for Amazon subpoena returns? Assistant United States Attorney, Southern District of New York, 1 St. Andrews Plaza, New York. New York, 10007. From USANYS Redacted. Contractor. Sent Thursday, November 11th. To ALR Redacted. Subject. RE. Amazon Return. USANYS Redacted. Contractor. I've added it to the pending Rule 16 production and have saved it to the trial subpoena returns folder here. w.usa.doj.govcloud.ny, St. Andrews Sheriff Os Epstein, 2018, R0161. Mitrian Trial Subpoena Returns Amazon the 10th of November, 2021. Let me know if you want this pending Rule 16 production Prep to go out today with the 3500 in GX. Right now, the pending production just has these Amazon returns. From Redacted. Sent Thursday, November 11th, 20,219 to 46 a.m. To USANYS Redacted. Contractor. CC. Redacted. Subject. RE. Amazon return. Thanks, Sonny. Yes, good to go with this production. From Redacted. To USANYS Redacted. Contractor. CC. USANYS Redacted. Contractor. Subject. RE. Amazon return. Date. Thursday, the 11th of November, 2021. 18 hours, 42 minutes, and 58 seconds p.m. Attachments. The 11th of November, 2021. _ Discovery. _letter.docx. USANYS Redacted. USANYS Redacted. These returns have been stamped here. USA.doj.go. VK Klukanis. St. Andrews Shareju. SVEP. STEIN. 2018. R01618. Discovery GM 3728th production. Draft Discovery cover letter is attached and saved here for your review. U.S. Department of Justice, United States Attorney, Southern District of New York. The Silvio J. Malo Building, 1 St. Andrews Plaza, New York, 10007. November 18, 2021. BY email. The Honorable Allison J. Nathan, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007. Re. United States v. Ghislaine Maxwell, S220, Crossing 330, MN. Dear Judge Nathan, the government respectfully submits this letter motion to quash the defendant's Rule 17, C3, subpoena to the administrator of the Epstein Victims Compensation Program, EVCP. For the reasons set forth below, the subpoena should be quashed. I. Applicable law. As the defendant acknowledges, she bears the burden of satisfying the standard in United States v. Nixon, 418 U.S. 683, 1974. Def. Mott. At 1. Pursuant to that standard, the party seeking issuance of a Rule 17c subpoena must clear 3 hurdles. 1. Relevancy. 2. Admissibility. 3. Specificity. United States v. Cole, 2021, WL912425, at *3, SDNY March 10, 2021, internal quotation marks omitted. The proponent must also establish that the records sought are not otherwise procurable. ID, quoting Nixon, 418 U.S., at 699 to 700. For sake of simplicity, the government uses the term minor victims to include WITNESS3. The government acknowledges the court's order that witness 3 should not be referenced at trial as a victim. Odin, EFTA 00010118. Page 2. The Nixon test is enforced strictly. As the Supreme Court has explained, it was not intended by Rule 16 to give a limited right of discovery, and then by Rule 17 to give a right of discovery in the broadest terms. Bowman-Dairy County v. United States, 1951. See also United States v. Purin. A subpoena ducis tecum in a criminal case is not intended as a means of discovery. It is not sufficient for a party to show only that the subpoenaed documents are potentially relevant or admissible. United States v. Way, SDNY 2017. Internal quotation marks omitted. See United States v. Skelos. The materials sought under Rule 17 must themselves be admissible at trial. It is not enough that they contain information which could be admissible. Alterations and internal quotation marks omitted. United States v. R.W. Professor Leasing serves. EDNY 2005. Explaining that it is insufficient for a party to show only that the subpoenaed documents are potentially relevant or may be admissible. Similarly, the party requesting the subpoena must also show that the application is made in good faith and is not intended as a general fishing expedition. United States v. Ulbricht, quoting Nixon, 418 U.S. at 699 to 700. Internal quotation marks omitted. Abrogated on other grounds as recognized by United States v. Chambers. Summary order. 1. Discussion. The defendant has subpoenaed 4 categories of information. 1. Copies of any payments to the minor victims and their counsel. And 2. Any and 111 releases executed by the minor 2. Although generally production of impeaching evidence pursuant to Rule 17c is not required until after the witness testifies. Skelos, 2018 WL 2254538, at 2, In this case, the government expects each of the minor victims named in the subpoena to testify at trial. Accordingly, if the court permits enforcement of the subpoena, the government does not object to production of the records to the court before the minor victims actually testify for the sake of efficiency. Odin, EFTA 00010119. Page 3. Victims 3. Any and all material submitted by each minor victim to the EVCP and communications between the EVCP and the minor victims or their counsel. Def. Mot. Attachment A. The subpoena should be quashed as to each of these categories. A. Payment records. The first category, copies of payments made to the minor victims, concerns information already in the defendant's possession. Indeed, the defendant's motion cites the amounts received by the minor victims, which is reflected in their 3,500 material. Def. Mot. At 3. And the government expects the minor victims to testify to those amounts at trial. Accordingly, this information is otherwise procurable. United States v. Peña, SDNY, February 12, 2016. The subpoena should therefore be quashed. At most, the court should order production of that information to the court so that it may be provided to the defense in the unlikely event that the minor victims testify inconsistently with their prior statements at trial. B. Claim release forms. The defendant makes no argument for the relevance of the release forms executed by the minor victims, and none is apparent to the government. The court should therefore quash the subpoena insofar as it calls for that category information, at least until the defendant explains what relevant and admissible evidence is contained in the release forms. Odin, EFTA 00010120. Page 4. C. Any and all material submitted to the EVCP. The defendant makes a further request for any and all submissions by the minor victims to the EVCP. This request would not generate relevant, admissible evidence for two reasons. First, the defendant has not identified a theory by which these materials are relevant and admissible. The defendant argues primarily that the materials contain relevant impeachment information because, quote, and complete cross-examination is impossible without understanding the complete terms of the agreement with the Epstein Fund, including the claims concerning Maxwell as well as others. Def. Mot. At 6. Materials are not relevant and admissible at trial, as required by Nixon, simply because they aid the defendant's understanding, and the defendant articulates only one theory by which EVCP materials may be admitted to show bias. According to the defendant, the May 2020 protocol governing the EVCP states that claims are evaluated depending on whether there exists any information and/or pertinent findings offered by the appropriate United States Attorney's Office or other law enforcement agency. Def. Mot. At 5. If this, quote, prosecution against the defendant went forward, the argument goes, the minor victims and their lawyers would benefit. ID. The defendant already has the information relevant to this argument. She has the protocol for the EVCP. The government has offered no information or findings to the EVCP about the minor victims. To the extent the EVCP relied on publicly available information about this case to make its determination, such as the charging instruments in this case, that information is in the public record. And the government has already disclosed to the defendant the settlement. Odin, EFTA 00010121. Page 5. Amounts, which the defendant cites in her motion. Def. Mot. At 5. Thus, if these records are relevant at all, they are otherwise procurable. The defendant also argues that the subpoenaed records contain prior statements of the minor victims, presumably suggesting that they may be admissible as prior inconsistent statements. Def. Mot. At 4. This argument misses the mark. Any statements in the EVCP's files are unlikely to be inconsistent in light of the context in which they were made. See United States v. Barrow, citing United States v. Strother, for the proposition that an omission in a prior statement should have been admitted as an inconsistent statement because it would have been natural for the witness to include the fact. Internal quotation marks and alterations omitted. In order to initiate a proceeding with the Epstein Victims Compensation Fund, a victim must articulate a claim directed against Epstein. INDEP, Epstein Victims Compensation Program Protocol, Def. Mot. X1, Attachment A3. Emphasis added. And in that context, it would be wholly unsurprising if victims spoke at times about their experience with Epstein without discussing the defendant. Further, if it were true, as the defendant argues above, that EVCP funds will reveal the minor victim's bias because their recovery from the EVCP was aided by the government's continued case against the defendant, One would expect that any statements by the minor victims to the EVCP regarding the defendant would be consistent with their statements to the government and at trial. If the minor four. Indeed, because all four minor victims identified in the subpoena have resolved their claims with the EVCP, there is no reason to think their trial testimony will be biased in order to advance their claims in a now completed settlement process. 5. Consider, for instance, if a victim met Epstein and the defendant together on a certain date. It would be entirely consistent for the victim to testify as much on the stand and to tell the EVCP that she met Epstein without mentioning the defendant on that date. Odin, EFTA 00010122. Page 6. Victims' submissions to the EVCP did not discuss the defendant. A criminal case against the defendant would not advance their claims. Second, even if these subpoenas yielded marginally relevant impeachment material or marginally inconsistent statements notwithstanding their context, such evidence would not be admissible under Rule 403. At the November 1, 2021 conference, the defendant sought to preclude the government from arguing that the minor victims' settlements with the EVCP reflects an endorsement of their claims, which would be confusing to the jury, and open the door to an explanation from the defense about what really happened in those proceedings, a request to which the court and government agreed. It remains the government's position that cross-examination highlighting the fact that the minor victims received large settlements for their claims would not open the door to a broader discussion of the Epstein victims' compensation program. If, however, the defendant engages in significant cross-examination about what minor victims did and did not say to the EVCP and the reasons for those statements, it would create just that confusion and open just that door. If the defendant argues that a minor victim should have, but did not, make statements about the defendant to the EVCP, the government will have to explain to the jury the purpose of the EVCP and its adjudicative process in order to contextualize that omission. Similarly, if the defendant argues that the minor victim's testimony was biased by some interrelationship between the EVCP and this case, the government will have to explain to the jury the absence of such an interrelationship, including the timeline of the minor victim's statements relative to the timeline of the EVCP. Indeed, it appears that the defendant anticipates arguing that some minor victim's bias is shown by the fact that their counsel was involved in structuring the EVCP, which would require further response from the government about the Odin, EFTA 00010123. Page 7. Operations of the EVCP. Def. Mott. At 5. Lawyers for Accuser 2 and Witness 3 were instrumental in creating and structuring the terms of the protocol. The risk of confusing the issues and wasting time at trial substantially outweigh any probative value in the evidence the defendant might obtain. This is not a trial about the scope and adjudicative process of the EVCP. All of this should be precluded, and therefore none of it is admissible under Nixon. The defendant is able to make arguments about bias and consistency without issuing a subpoena that is unlikely to yield relevant information that would be precluded at trial in any event. Degree. 5. Communications. Finally, the subpoena calls for communications between EVCP and the minor victims and their counsel. The term communications is defined broadly, covering all forms of correspondence, including regular mail, email, text messages, memorandum, or other written communication of information of any kind. This subpoena request is a classic fishing expedition that the court should quash. There is no reason to believe that the minor victim or their counsel would make substantive statements, which might be inconsistent, in emails and text messages. The defendant offers no reason why their theory of bias would find support in correspondence, nor is one supported by logic. The theory is that the minor victims told false stories to the government to advance the prosecution, not that they did or said biased things to the EVCP. This subpoena does not seek to obtain identified evidence, but rather to engage in a general "fishing expedition" that attempts to use the blank. 6. The defendant defines EVCP material to include information regarding compensation received by minor victims and releases signed by them. Def. Mott. X1. Attachment A. Those items should be treated identically to the specific requests for them, as discussed above. Odin. EFTA 00010124. Page 8. Rule as a discovery device. United States versus Cuthbertson. Such an expedition is precluded by Nixon. 418 U.S. at 700. 3. Conclusion. For the foregoing reasons, the court should quash the defendant's subpoena. Respectfully submitted, Damian Williams, United States Attorney, by Mr. Redacted. Assistant United States Attorneys CC, Counsel of Record, by email. In the event the court does not quash the subpoena, the government notes that it is returnable to the court for in-camera review. Def. Mot. At 1. To the extent the court releases any records from the EVCP to the defendant, it should only release those records that comply with the Nixon standard. See Skelos, 2018. To avoid delay in trial, courts sometimes require production of impeaching material to the court, but not to counsel, with the court reviewing these documents in camera and then disclosing any admissible documents only after the witness testifies. For instance, if the court identifies prior inconsistent statement in only one document, no other records should be released to the defendant. And, in addition to evaluating whether any statement is relevant to show bias, or as a prior inconsistent statement, the court should consider whether it is precluded under Rule 403 for the reasons described above. See Supra pp. 6-7. Odin, EFTA 00010125. From Gadher Depeche. Date: July 20, 2021 at 3:5:20 p.m. Eastern Daylight Saving Time. 2. USANYS redacted. Subject: Ghislaine Maxwell update. Dear Nick, I hope this email finds you well. Since we last spoke, I've been juggling work with the arrival of a lockdown baby boy, our firstborn, who has left me totally sleep-deprived. And thrilled, of course. I wanted to check a few things with you, if I may, on the Ghislaine Maxwell case. Is it correct to say that there will now be 2 trials? The first on the child sex trafficking charges, covering the period 1994 to 2004, and the second on the 2016 perjury charges? 2. Is the main trial still scheduled to start in November? 3. Is there any date set aside for the perjury trial? 4. What does this mean for the maximum sentence that Maxwell can now receive? I think we previously settled on up to 80 years behind bars. 5. Is the investigation into Maxwell and Epstein's network still ongoing? 6. If so, does Prince Andrew remain a person of interest? Have U.S. prosecutors managed to get a statement from him yet? Or are there any arrangements in the pipeline to do so? I'd be grateful if you could drop me a line with some responses within the next 48 hours, if at possible, please. Many thanks. All the best. Depeche, The Sunday Times. Please consider the environment before printing this email. This email and any attachments are confidential, may be legally privileged, and are the property of News Corp UK and Ireland Limited, on whose systems they were generated. News Corp UK and Ireland Limited is the holding company for the News UK Group, is registered in England and Wales under number 81701, has its registered office at, and is registered with VAT number GB243805469. If you have received this email in error, please notify the sender immediately and do not use, distribute, store, or copy it in any way. Statements or opinions in this email or any attachment are those of the author and are not necessarily agreed or authorized by News Corp UK and Ireland Limited or any member of its group. News Corp UK and Ireland Limited may monitor outgoing or incoming emails as permitted by law. It accepts no liability for viruses introduced by this email or attachments. News Corp UK and Ireland Limited and its titles are committed to abiding by IPSO's regulations and the editor's code of practice that IPSO enforces. From redacted. Date: Tuesday, July 20, 2021 at 3:11:36 p.m. Eastern Daylight Saving Time. 2. Redacted. CC. Redacted. Subject: Forwarded message Ghislaine Maxwell update. USANYS. Allah redacted. I know all of the answers, except number 6. Defer to you on how to handle that one, unless you think that's a better question for... Thanks. Sent from my iPhone. From USANYS. Almin redacted. 2. 111 Amin redacted. Subject: Forwarded message Ghislaine Maxwell update. Date: Tuesday, the 20th of July, 2021, 19 hours, 29 minutes and 56 seconds p.m. FYI. Sent from my iPhone. Odin, EFTA 00010139, and EFTA 00010140. If you have enjoyed this video and the time it takes me review these documents and then bring them to you, then please like this video, share it, and leave your comments in the comments section. Please share this so as many people as possible can hear these messages and hopefully these articles can finally be heard. As always, I will see you next time. Stay safe, stay alert, and stay suspicious.